When it comes to your retirement, do you want to have the same old plan everyone else has? Of course not. You're unique and have your own goals and dreams. Don't be treated just like a number. This is your retirement. So it's time to think differently. And you're in luck because you've found the Retire Your Way podcast with ILG Financial. At ILG Financial, you won't find generic, run-of-the-mill plans containing the same old cookie-cutter solutions. Dave Chase and the ILG Financial team focus on building one retirement at a time using their Think Differently philosophy. And that means your own comprehensive plan with customized solutions built to achieve just one goal, yours. So put on your Think Differently hats and get ready to take back control of your retirement today and for all the tomorrows to come. ILG Financial's Retire Your Way podcast was created just for you, and it's starting right now.
When it comes to retirement, do you want to have the same old plan everyone else has? Of course not. You're unique and have your own goals and dreams. Don't be treated just like a number. This is your retirement, so it's time to think differently. And you're in luck because it's time now for the ILG Financial Retire Your Way podcast, brought to you by ILG Financial. And they focus on building one retirement at a time using that Think Differently philosophy. So, welcome to the show. We have a very important topic today, that of caregiving. And I think you will find this very, very interesting and very informative. Caregiving is something that affects so many people, maybe you, or maybe it will affect you in the future. Right now, without any further ado, let's introduce Dave Lopez and get this started. Dave and his special guest, Jeremy Pryor.
Well, thank you, Ron. It's good to be back. Always good to be back on the podcast. Really special guest we have today. I've been looking forward to this all month. Today we have on the line with us Jeremy Pryor. Jeremy is a principal attorney at the law firm of Carell, Blanton and Ferris and Associates. They're out of Richmond, Virginia. We work very closely with them, with several of our clients, on preparing wills and trust and estate planning documents. And Jeremy, at first I want to say thanks for taking the time. I know you are a busy fella, but sure appreciate you taking the time to share with our listeners some things that we want to know about what happens with end-of-life care. And what we're looking for today is to get your perspective based on your specialty. And for those listening, Jeremy serves as the chair of the elder law section of the firm, and his area of practice includes elder law, estate planning, and incapacity-related litigation. Did I get that right, Jeremy?
Yeah, and I'm so glad to be here. Thank you for inviting me.
We appreciate it. And really excited to talk to you today. And the reason is that we've talked before on the podcast about different ways to pay for care. But as we're going to talk about today, that is the tip of the iceberg of what we would need to know if a family member needs care. So what I'm going to do to tap your expertise on this podcast, Jeremy, is let's just talk about this idea of navigating care for a loved one. And I'm going to kind of let you take the reins on this. And let's just start with a 10,000-foot view of what this kind of looks as it would start to unroll for a family. Mm-hmm. What we would need to know about who makes decisions, what the responsible family member, how we would handle medical decisions, how we would handle financial decisions. And then as we'll go through it and talk about, different things that pop up. So
sure.
Give us that 10,000-foot view.
Yeah, absolutely. So I often meet with clients who are concerned about, care and trying to figure out how to get the care that's required, and then secondly, typically how to pay for the care. But when it comes to various care options in Virginia, I always explain to clients that there's effectively 3 different licensed professional providers of care. And maybe before I even explain what they are, let me step back for a second and talk a little bit about care itself. So when I'm helping clients, they're typically thinking about the need for what we call long-term care, sometimes called personal care, sometimes called custodial care, or it has a number of different names. But the basic idea is someone who requires care with activities of daily living. So classically, there's bathing, dressing, feeding, toileting, and walking. There are some other activities of daily living that sometimes get lumped in with those, like medication management or need for supervision. But fundamentally, you can think of the type of care that most of the folks are trying to navigate as help with the basic things that we do every day. I sometimes think of it a little bit like caring for young children. I'm a father. I have 3 young children, and I know very well what they require day to day to just get through the day and do the things that need to be done. But those are really similar care needs for adults as they age and start to lose functionality, typically physically, sometimes cognitively. But when that happens and somebody requires help with those activities, a lot of times the first persons that step in to help are family members, spouses, adult children, sometimes neighbors and friends, and they just assist the individual as needed to get those things done. But when we start to talk about professional care options in Virginia, we have 3 types that are licensed to provide long-term care, and they all do it slightly differently. So the first option that's out there is what we would call an in-home care agency, and there's a number of these in most parts of the state that I'm familiar with, and their model is to basically send someone into the home of the individual who requires the care, and that person that's sent to the home will help with the activities of daily living. They typically get paid by the hour. We're talking in summer of 2026, the market rate for in-home care these days, as far as I can tell, is somewhere between $30 and $40 an hour. And the agencies will typically send someone into the home to provide as much care as the individual wants to receive. Sometimes it's a couple hours a day, sometimes it's a couple hours a week, sometimes it's just, light assistance, sometimes it's more intense. But that's one professional option that's available when someone starts to consider their need for long-term care. The second professional option in the Commonwealth of Virginia is an assisted living community. Now, these communities have really taken off in the last 15 to 20 years, I'd say, maybe even sooner or earlier than that. But they offer fundamentally a residential environment. And so when someone relocates into an assisted living community, they basically are going to sign a lease agreement and agree to pay a monthly amount for the room and board. And then they typically will have an additional amount that'll be charged to provide care to the resident. And the additional charge per month will typically be assessed based on the care needs. So someone who moves into an assisted living community and really doesn't require much care may just pay for the room and the board. An individual who moves into an assisted living community and requires daily care will presumably pay more to live in the assisted living than someone in the independent living part of the building. And some assisted living communities, not all of them, but some of them have what's called a memory care unit within the assisted living community. And the memory care unit is typically reserved for individuals who are suffering from severe or advanced dementia. The cost of that care can vary greatly. Some of the assisted living communities are trying to provide a very high standard of life for their residents, and so they may have lots of amenities, things like libraries and social events and bars and swimming pools and a gourmet dining hall. Others are going to be trying to provide a more functional or practical environment, and they may not cost as much. But obviously the factors that can affect the cost for that kind of care are going to be dependent upon the level or quality that the assisted living community is offering generally, and then also the amount of care that the particular resident is going to require. And in my experience right now, it's usually somewhere between maybe $4,500 a month on the low end for an assisted living community. And for someone who's in a memory care unit in a pretty nice place, it might be as high as $10,000 or $11,000 a month. So it can vary quite a lot.
Can you tell me real quick, this comes up quite a bit for us, what usually is the difference in care that would cause someone to move from the regular assisted living with assistance and switch into the memory care unit portion of the assisted living facility?
Yeah, that's a great question. The factors are typically going to be related to the cognitive ability of the resident as opposed to the physical abilities of the resident. So for someone who perhaps physically could do quite a lot for themselves, but is at a point where they really cannot be left unsupervised for an extended period of time, or there's a concern that they might wander and inadvertently endanger themselves, those are situations that typically will cause someone to move from the regular assisted living portion of the community to the memory care unit. It's not typically so much about the physical needs as it is the mental abilities of the particular resident.
So even though they have open reign inside a regular assisted living portion of the facility, they'd move to the memory care if they're worried about even inside the facility them roaming because they weren't sure where their room was or things like that, correct?
Yes, that's exactly right. It's typically, and I should have said this too, memory care units will typically have secured exits and entrances, and they'll have more staff on the floor to keep a closer eye on the residents just to ensure that they don't endanger themselves. That's the primary concern.
But inside that sealed environment, which is a little separate from the rest of the assisted living community, correct?
That's right. Yep.
Inside that sealed environment, they could still move around outside their room, just it's monitored more closely, correct?
Correct. Yep. That's generally true. Yeah. So those are two of the three common professional options that clients will consider when they are thinking about potential ways to receive long-term care. The third option, professional option in Virginia, is the skilled nursing facility. And this is a very different model of care than your assisted living community. A skilled nursing facility is first and foremost a medical environment. They are typically attached to rehab hospitals. In other words, it's the most common way for someone to receive care in a skilled nursing facility is to have entered the particular facility as a rehab patient upon discharge from a hospital setting. And that resident or that patient at that point will relocate there to continue the rehab related to whatever event caused them to be hospitalized. And that rehab process typically takes no more than 100 days. There are certain insurance reasons why most of the rehab is only going to last 90 to 100, up to 100 days at the most. But if the particular patient who's entered that rehab hospital for rehab purposes does not reach a point where they can move home or move back to the residence they occupied before they went there, then the rehab facility will transition that particular patient from the rehab side of the facility to the long-term care side of the facility. And that is a change in their status that may not feel like much of a practical change to the particular patient, because the portion of the facility that's typically reserved for long-term care still feels quite a bit like a hospital. Typically going to have the wider hallways and the shared rooms, and of course they do feed all of their residents, but it's not typically going to be a fine dining environment like some of these assisted livings. The person who relocates to the long-term care side of the facility does get all of their care needs met there. So all of the activities of daily living needs and any other needs can typically be met in the long-term care side of the rehab facility. And that is, frankly, the most expensive option of the three. And it's not, I guess I should say, strictly reserved for individuals who come from a hospital. It is possible to basically relocate directly from your residence to a skilled nursing facility to receive long-term care. It's the most common way is to go in through the rehab hospital, but that's not exclusive. But regardless, the cost of living in the long-term care side of a rehab hospital is going to be somewhere between usually $11,000 and $13,000 a month, at least currently. So it is another professional option that's available alongside the other two, but the model for the care that they offer is different. It's fundamentally a medical environment. And because of that, they have additional staff to meet medical needs of all of their residents. So they have to have doctors and nurses and other trained medical professionals on staff to be able to do those things. And that makes the cost of receiving even basic long-term care in a skilled nursing facility much higher than it would be in some of the others, even if the particular individual could theoretically receive care in some of the others.
I see. So it'd be fair to say that this one you described, this is the one most of us are familiar with when we hear the term a nursing home.
That's right. Yeah,
right. It's
that's
that
exactly
last
right.
stop, much like a hospital. Often folks that are bedridden.
Mm-hmm.
Right.
Mm-hmm.
So if you broke your hip, you would go in there temporarily to rehab. And if you could recover from that and move around, they'd move you back to your assisted living facility or your memory care unit.
Mm-hmm.
Right.
That's correct. Yep.
So that's, would it be fair to say that's also one that you, over time, on average, have the shortest stay in because it's either end of life or you recover?
Yeah, I don't know the exact data on all the different, potential professional options, but I think that's a pretty true thing to assume.
Okay, so we've got those three types. Let's talk about what we would need to know as family members as far as navigating the whole process of someone going through this, whether it was from a fall or starting to have memory issues or any of the other issues as they start to progress from either going to the hospital first or something happening or just being aware that they can't take care of themselves at home anymore.
Yeah. No, the most important thing that, if I'm ever talking to a potential client, and it's often the case that I'm not actually talking to the person who needs the care immediately, I'm talking to a family member or a spouse.
Right.
So the most important thing that I'm concerned to ensure is in place are some legal tools that we would hopefully, or the client would have hopefully taken care of before the need for care became an issue. In Virginia, there's two legal tools that we typically advise clients to put in place to address potential issues related to incapacity. The first of those is called a durable or a general durable power of attorney, and the second is called an advance directive or an advance medical directive. In any situation where someone requires care, they typically are going to benefit from having other persons who have legal authority to make decisions and get things done related to the care need. It's not impossible for someone who needs care to make those decisions for themselves, but it can be very difficult as a practical matter to do all the things that may be needed, get to the bank and just make arrangements to sign lease agreements or, find doctors and all of those sorts of things. But those are the two fundamental tools that we hope when anybody needs care, they've already done. If they haven't already done them, again, as long as they still have the ability to sign legal documents, that's independent determination, relative to a care determination. As I think I said, the care needs are usually more physical than mental in nature. But when we talk about standards for signing legal documents, we don't care about somebody's physical limitations. We only are concerned about their potential cognitive limitations. But those are the two key legal tools that we want to make sure someone either already has in place, and if they don't, then hopefully they still have the capacity to sign them now and involve people that they choose to help make those kinds of decisions.
Yeah, and this is a great point, Jeremy. I'm glad you brought it up because would it be fair to say this is one of those things we tell folks that is a huge pitfall, that if you miss it, there's no going back, right?
Yeah.
We need these documents in place before your family member starts to show diminished capacity mentally.
Mm-hmm.
Because once that happens, the door shuts on the opportunity to do this or makes it very difficult, right? The next step, if you needed to help your loved one and they've already shown diminished capacity, now it becomes much more complicated, does it not?
Oh, yeah. No, I have had a number of occasions over the years where unfortunately the person who needs the care has not executed the documents that would allow others to help. In those cases, unfortunately, we have to go to court and we have to pursue what's called a guardianship and a conservatorship. And fundamentally, the individual who gets authority to make decisions through the court gets the same authority that they could have had if the individual had signed those documents. It just costs 10 times as much money and takes 10 times as long to end up in the same place that they could have been had it been addressed before the need came up. So definitely not something to put off if you're thinking about it.
Well, and to add to that, that durable power of attorney, if I'm not mistaken, I'm deferring to you on this, Jeremy. Once that's in place, the elder family member still can make their own financial decisions. It's kind of like just both of you can make decisions, correct?
Yeah, no, that's a great point. And I think a lot of times when I counsel clients about signing these documents, they have an underlying fear that if they do this, that this person who they're saying will be able to act for them is going to be able to, do whatever they want and make all these decisions, even if the person who signed it disagrees. And that's just fundamentally not true. And in every power of attorney, the person who you name to serve as your agent has what we call a duty of loyalty. And that means that that person cannot use it against you. In other words, if you have signed a power of attorney and you've given somebody authority to act as your agent, they don't have a blank check to start doing whatever they think is best for you. They have to work with you and they have to take their instructions from you. And fundamentally, you can remove them as your agent anytime you want to. So if that person isn't doing the things that they should be doing and they're trying to use it against you, so to speak, then you should probably think about removing them. If not, just remove them immediately.
Yeah, so let's pull that thread a little bit. So let's say, Jeremy, you and I are brothers, and our dad has signed this agreement, this durable power of attorney, while he still has all his mental faculties. And 2 years later, he starts to show diminished capacity. And he's having trouble with the bank accounts or this and that. But in his head, he's still thinking he's fine. And we're trying to help with the bank accounts. And he's like, well, I don't want you in my bank accounts. But at this point, he's already showing signs of diminished capacity. How does that play out? Do we, as the power of attorney folks, even with diminished capacity, if he's saying, look, don't do that, and I want to take this money and go on a trip or something, and it's not in his best interest, could you and I, with the power of attorney, still act, or we still have to follow his requests?
Yeah, it can get sticky in some of those situations because it will depend to some degree on whether he is, well, a couple different things. The first thing it might depend on is whether he's telling the agent to do something or not to do something. If he tells the agent to do something and the agent doesn't think it's a good idea, the agent isn't required to do it. The agent can say, I know that you really want me to, take your savings account and go down to the horse track and put it all on this particular pony. That doesn't mean the agent has to do it. But if the person who signed the power of attorney tells the agent not to do a particular thing, that typically is going to be binding on the agent. In other words, the example I often use is, let's imagine that, the person who's signed the power of attorney tells the agent, well, I had a terrible experience with this particular bank. I really don't want you to ever use them for anything. Well, that kind of instruction typically will be binding on the agent. There's a distinction or a difference to be made between a proactive instruction to do something versus a prohibition to do something. But even in assuming that the principal has told the agent, I don't want you in my bank account anymore, don't do it, that type of instruction typically would be binding on the agent, and it creates some potential for problems where the agent perhaps does have a better sense of the danger and the problems that the person is going through than the person himself does. But generally speaking, the agent's going to have to be very sensitive and respect the instructions of the principal, even in those types of situations. There is what I would say a common sense limitation on that. Again, if you're the person who you're acting as agent for has done something that immediately endangers himself and doesn't want you to fix it, that may be a situation where the agent can say, I really think that even in spite of you saying don't do something, I need to do this to preserve your life or your health or your financial well-being. I don't want to stretch that too far. And fundamentally or ultimately, these types of situations will sometimes have to be resolved by courts through those guardianship conservatorship type proceedings. I've got a case right now with a a client who has made some poor decisions, and in spite of the fact that he is her agent, he's had to respect it, and he has decided that the decisions that she's making are concerning enough that he's going to ask a court to appoint him as her guardian. One of the big difference, I guess this would be an important thing to clarify, big difference between an agent under a power of attorney and a guardian or a conservator is that the guardian or conservator can override or object to the instructions of the incapacitated person, whereas the agent cannot. So in those situations where there's really a problem and the person unfortunately doesn't realize that they're suffering from diminished capacity, the agent is going to be in a tough spot trying to navigate that. Hopefully they can work it out with that person and they can come to an agreement on how to resolve it. But if it is intractable, there's probably not going to be any other solution than that guardianship conservatorship option. And that is through the courts. The person who is allegedly making the poor decisions will have, at least in Virginia, an opportunity to present evidence to the judge that disputes the characterizations of the agent or whoever is asking for it. And it's not ideal for a lot of reasons, but it is the only effective legal remedy in some of these cases.
So I appreciate you saying that. And this is one of the reasons that we've really enjoyed this and appreciated this relationship with your firm. Mm-hmm. Because this is the great example. We can get the paperwork in place, but when this type of thing starts happening, having access to you all as if we were your clients mm-hmm. Is a real sense of relief that you're not, as the agent of the power of attorney, trying to decide at what point you have to go to a court to protect yourself, right, from the patient. Mm-hmm. And do I get that right? Would that be your advice to your clients? We've got the documents in place. If you have any questions on navigating your role as the agent, you can reach back out to us.
Mm-hmm. Yes. So we often will. I had a meeting with a former client, the daughter of a former client, a few weeks ago, and she had been appointed by her mom as her mom's agent, and she was concerned that perhaps some of the decisions her mom was making were not good for her, and she wanted to help her mom, and she wanted to know and understand, what can I do as my mom's agent and my mom's healthcare agent to be able to help her? And we had a conversation about the specific issues that she was facing with her mom, and kind of, a lot of questions about, how bad are these decisions? The law generally is very concerned to preserve somebody's rights to continue to make their own decisions as long as they're capable of doing it. And so we don't rush into a guardianship or a conservatorship. It only is something that's pursued as what I call a remedy of last resort. This is the only possible solution to a very clear problem. Okay, courts are willing to do that in those types of cases, but if it's less than that, if the individual, if I decide today to take my life savings and go, bet it on a horse in a track, then that's up to me. Nobody can tell me not to, even if it's a terrible financial decision. So there is a fine line there, but the courts are really concerned to preserve individuals' abilities to make their own legal decisions as long as they have the ability to do it, and are not going to look favorably on people that just favor or just, try to use this court tool to get authority over someone else.
Makes sense. Well, Yep. This has been super. I'm glad we pulled this thread, because this is something that's not talked about enough. Mm-hmm. So let's kind of wrap up the talk today, Jeremy, with this idea. I want to make sure I got your major points, which is, sooner than later, if there's one thing you could tell the folks listening, it would be sooner than later, while your adult, elderly family member, let's say parent or grandparent, has mm-hmm. all their mental faculties, mm-hmm. have this discussion of getting the general durable power of attorney and the medical directives in place.
Yes, absolutely.
Right? And ideally, if you can engage a firm like yours, you all can walk the patient or the senior family member through it, so that the children don't have to.
That's right. No, in fact, I would prefer to talk to the client without don't mean any offense to the children who are doing this for all the right reasons, but part of my job is to make sure that the person who is sitting down with me and asking me to help them prepare this document is someone who really still fully understands what they're doing, why they're doing it, who they're appointing. They have the ability to still sign something like this. And that's often a conversation that's best had, at least for a portion of it, in private. If the particular client wants other adult family members in the room and involved, that's okay. That's their prerogative. But that's a part of any lawyer's job, is to hopefully ensure that the person who's signing this document is capable and understands what they're doing.
Yeah, that actually helps the children too.
It does.
Right, because you're in a position later to say the children weren't even in the room, and I spoke with this person one-on-one. They were sound mind. They understood. They wanted the kids in this juncture involved with the power of attorney and the medical directives.
That's right. Yep, exactly.
What you've shown me, Jeremy, if you'd be open to it, is later in the year, let's have you back, because I think we just scratched the surface on the stuff you and I had wanted to discuss.
Yeah. No, I probably need to be a little briefer in the future, but there's a lot to say. And if you've done a lot of this, then you see a lot of things that help to contextualize situations. Yeah,
but it's helpful to go through these specific examples. I know it is for me and for the folks listening. So we'll have you back if you're open to it. We sure appreciate your time.
Yeah, and
yeah, and then I will, with your permission, if we have folks calling in that see the need for this, we're going to pass your information over so you or your team can give them a more private and very specific explanation of how you might be able to help in their case.
Well, I really appreciate it. Thank you so much for having me, and I'd be happy to come back.
Yeah, well, great. I look forward to it.
Income, legacy, growth, it's all right here at ILG Financial. Thank you so much, Dave and Jeremy. That was incredibly informative, and I know that you've reached a lot of people with that message and that conversation. It's all about helping you plan for retirement your way so you can achieve your financial goals. Call ILG Financial at 540-720-5656, or you can go online to ilgfinancial.com to learn more. This has been the Retire Your Way podcast with Dave Lopez. Thanks for listening, and we will see you next time. The information provided is for educational purposes only and is not intended as investment advice for any individual or entity. All information contained herein is believed to be from reliable sources. However, we make no representation as to its completeness or accuracy. The views presented today are those of Dave Lopez and do not necessarily represent the views of the Alpha Star Capital Management, LLC. The opinions expressed are subject to change without notice and do not constitute financial, legal, or tax advice. Please consult your financial professional before executing any financial strategy. Investment advisory services offered through Alpha Star Capital Management, LLC, a registered investment advisor. Alpha Star and ILG Financial, LLC are independent entities. SEC registration does not constitute an endorsement of the firm by the Commission, nor does it indicate that the advisor has attained a particular level of skill or ability.
Hey, Chase Lopez here. Thanks for listening to Retire Your Way with ILG Financial, our podcast. Make sure you head to our YouTube channel as well to check out our video series, Retire Your Way with ILG Financial. Also, don't forget to subscribe and like our videos there so you can be alerted for any future videos. Talk to you soon.